Good morning, my magnificent young entrepreneurs. Are you ready to learn some law and make some money? Well, we're in the second part of our section on torts now. We finished up on intentional torts, and now we're going to do negligence and strict liability. First thing we're going to do is negligence. A negligence tort is an unintentional act, usually carelessness, the failure to exercise some degree of caution, which causes someone physical injury or damage to their property for which the law recognizes the right to compensation. There are four things, the elements that you must prove in order to win a lawsuit for negligence. The four elements of a cause of action for negligence are: one, that the defendant owed some form of duty of care to the plaintiff. So if I'm teaching you in a classroom and just before class a student comes in and spills a 60-ounce Slurpee on the floor, as the teacher in the classroom, I owe all of the students coming into that classroom a duty of care to get that cleaned up or roped off or something, because I have a responsibility to keep you safe in the classroom. But if at the same time someone is out on the campus sidewalks outside where I can't even see them, and they drop a banana peel on the sidewalk, well, perhaps somebody at Sierra College has a duty of care to get the slippery banana peel picked up off the sidewalk, but not me. I can't see it. I'm inside the classroom. I have no duty of care with regard to that banana peel out on the distant sidewalk. So the first one is that the defendant must have owed a duty of care to the plaintiff. And then there was the second element is there was some form of breach of the duty of care. The defendant was negligent, careless in some way. And then the third one is because of that carelessness, the plaintiff suffered some form of legally recognizable injury. So if you come rushing into my classroom and you slip and fall on the Slurpee that's spilled there, I didn't get it cleaned up or roped off, and if you have a broken bone and medical bills, well, you have a legally recognizable injury, and you can sue and recover damages. But if you slip and fall and you're not hurt, but everyone in the classroom laughs at you and you suffer embarrassment, the chances are you're not going to be able to sue me for a little bit of embarrassment caused by a slippery fall. So it must be a legally recognizable injury. And then the fourth element is that the breach of the duty of care, the act of carelessness, must be the cause of the injury. And that sounds very simple, except that it gets somewhat complicated, because in the law, cause is broken down with regard to tort liability. The cause is broken down into proximate cause and direct cause. So it must be both the direct cause and the proximate cause of the injury. And we'll go into that in more detail a little later. So those are the four elements of a cause of action for negligence. One, the defendant owed the plaintiff a duty of care. Two, there was a breach of the duty of care, some form of carelessness. Three, the plaintiff suffered some form of legally recognizable injury. And four, the breach of the duty of care was both the direct cause and the proximate cause of the injury. Now, when we have an allegation, a lawsuit, or a claim that someone was careless, negligent, and that carelessness caused injury, what standard of care do we use? How do we determine whether or not what that person did or failed to do fell below the standard of care? Well, we use what is called the reasonable man or the reasonable person standard. What would a reasonable person in the same or similar circumstances have done? If what the defendant did falls below the standard of care of what a reasonable person would have done, then we say that they were negligent and they may have liability. That raises an interesting question, though. What if you go in for brain surgery? You have a tumor in your brain, and you go in for brain surgery, and the brain surgeon removes the tumor, and that's great news. But after the surgery is over, you have an involuntary twitch in your arm, and there doesn't seem to be any way of stopping it. And then you want to know, when the brain surgeon did his surgery, did everything that he did fall within the standard of care, and it's just an unfortunate side effect of having a tumor removed that you have this permanent twitch in your arm? Or did he do something wrong when he was in there doing the surgery, and is his mistake what caused your permanent twitch in your arm? Well, how does any ordinary person know whether or not brain surgery fell below the standard of care? We don't have any way of knowing that. So when it comes to professional negligence, we do not use the reasonable man standard of care. We use what would be the standard of care of another professional person in the same circumstances. And so if we wanted to know whether or not the brain surgeon was careless, we would bring in another brain surgeon to review the medical records and see if he had an opinion about whether or not the surgeon did the job right or messed it up. So for professionals, we don't use the reasonable man standard, we use the peer standard. Landowners owe a duty of care to people that come onto their property to keep the property safe, and sometimes even if you are a trespasser, the landowner may have liability to you if he leaves a hazard on his property that causes you an injury. But there are levels of duty of care with regard to people who come onto your property. A trespasser is owed the lowest possible duty of care. A social invitee, someone that you invite onto your property to come to dinner or something, they're owed a higher level of care because you know that they're coming and you invited them. But there is an even higher level of duty of care, and that is if you own a business and you invite the public to come to your place of business. Those people are called business invitees, and you owe them the highest duty of care because, first of all, you invited them all to come, but secondly, you know that they're coming and they are all different levels of vulnerability. You're going to have children, you're going to have elderly people, you're going to have people with disabilities or injuries. So you're going to have all kinds of people coming onto your property, and so you have an even higher duty of care to protect them from dangers. I think that's it for the initial discussion of negligence, and so we'll stop there and we will go on with a closer look at the requirement of injury and causation.